Welcome, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am Rich Lenkov. I'm the founder and CEO of SERMA. I'm also the host of the SERMAPod, and we're very fortunate today to have a leader in the NIL industry. He is all over the place these days talking about NILs. He's got a busy practice representing players and business organizations dealing with sports. His law firm is Porter Wright. Luke Fedlam, welcome to the SERMAPod.
Rich, thank you so much for having me. It's great to see you.
So there's a breaking situation involving the Cavinder girls. This is Haley and Hannah Cavinder, who are college basketball players and TikTok superstars, right? They have over 4 million followers. They joined the Miami Hurricanes basketball program after transferring from Fresno State. And they were one of the early pioneers in name, image, and likeness endorsement deals, and they have run afoul of the NCAA recently. Why don't we start by you, if you can, explain to our listeners and viewers what NILs are, what the current status of that is, and then we'll get into what went wrong, allegedly, in this situation.
Sure. So name, image, and likeness really is the ability for college student athletes now to license the use of their persona rights, their right to their name, their image, their likeness. And licensing basically means they can lend it for a fee. So they can earn compensation by having their name, their image, their likeness associated with various brands and companies. But even beyond that, name, image, and likeness in this kind of new environment since July 1st of 2021 is really about college student athletes being able to earn compensation in ways that they never have before. They can run camps and clinics. They can, make appearances. They can sign autographs. They can do traditional kind of sports endorsement deals. All of these things that athletes have never had the right to do until about 18 months ago. So it is most certainly an interesting and busy time in this space. But when we talk NIL, that's what it's all about. And just to be clear, one thing for your listeners, I think it's important sometimes to really talk. There's really kind of two sides of name, image, and likeness. And this is what I think has really caused a lot of people to question kind of what exactly we're talking about. Because on the one hand, you have everything that I just said, right? Which is the traditional, I'm going to license to a company the ability to put my name on a product or on a service, and I'm going to get paid for that. And that is traditionally what NIL is meant to be. But what we've also seen is the involvement in creation of NIL collectives, having boosters and donors and others who put together deals, and I'll use that term loosely, in order for the ability to recruit and or retain particular talent at a specific institution. So there's kind of two sides of name, image, and likeness, and I think that's what makes it such a complex topic to talk about these days.
Yeah, for sure. I really appreciate that background. What prompted this NIL? What was the impetus to allowing student athletes to use their name, image, and likeness in this way?
So this has been something that's been talked about for years. We probably got the closest to allowing this during the Ed O'Bannon case, when Ed O'Bannon took on EA Sports and took on the NCAA, right? They were selling jerseys with student athletes' names on the back and getting paid off of that, and the athlete was getting nothing. And so ultimately, we thought we might see some change then, and we're talking kind of the early 2000s, like 2009 through 2013, 14 kind of time frame. It didn't happen. But in 2019, the state of California, from a state legislative perspective, passed a name, image, and likeness bill that turned into law that was set to go into effect in 2023. But then ultimately, Florida then said, well, if California is going to do it, we're going to do it. And Florida decided that we don't care about waiting till 2023. We'll make it effective July 1st of 2021. States all decided to follow suit. Of course, nobody wants to rule out the opportunity to recruit the best talent and be able to say that you can earn compensation. But the final straw, I think, was the NCAA versus Alston Supreme Court case, which was the oral arguments were heard in March of 2021, and the final decision from the court came late June of 2021, about 10 days before Florida and other states' laws were set to go into effect, where ultimately the Supreme Court of the United States said that the NCAA lost unanimously. And we all know these days, anything the court does unanimously is a really big deal, and said, hey, you don't have the right. It wasn't an NIL case. But ultimately, the heart of the question that was presented to the court was whether or not it was an antitrust violation for the NCAA to put caps or limits on education-related benefits. And in the court's analysis, they talked about the fact that the NCAA doesn't have the freedoms, these antitrust protections and freedoms that they thought they did. So ultimately, 2 days after that, the decision was rendered. The NCAA Board of Governors basically said, hey, everybody, we're going to suspend our bylaws related to earning compensation. And so if you're a school that's in a state that allows for name, image, and likeness, your school policy has to follow state law. And if you're a school that's in a state that doesn't have an NIL law in place, you just have to come up with your own NIL policy. And we're going to allow schools then independently to come up with their policy for student athletes to earn compensation.
It's really important, as you mentioned, student athletes earning compensation, to remember that while NILs is a groundbreaking innovation, it's a small sliver of the pie in terms of college athletics, right? I mean, in order to avail yourself of compensation from NILs, you still have to go out and sell yourself. And that's an incredibly small piece of the student athlete population. It doesn't mean that the NCAA or other leagues are sharing the incredible amount of revenue with athletes, as many have called for.
You're absolutely right. And I think you touched on one of the bigger issues that is still yet to face the college sports space, the college sports industry, which is revenue share. And from that perspective, when you look at things like conference realignment that help media deals, so you look at UCLA and USC joining the Big Ten, and because of that, the Big Ten signing a $7.5 billion media rights deal, a lot of people are saying, well, student athletes, since it's built on the backs of the student athletes' performances on the field, i.e. traditionally football, the student athletes should be able to in some way participate. Now, on his way out the door, Kevin Warren, the Big Ten commissioner who recently stepped down to take over running the Chicago Bears organization, he had some meetings with some various football players across the Big Ten to talk about this possibility of revenue share. But let's be clear, name, image, and likeness, NIL, is not related to revenue share, and it's not related to schools paying student athletes directly. It really is the freedom of agency, if you will, for student athletes to be able to go out and contract with a third party to be able to license their NIL.
So speaking of that, two student athletes who have done very well doing that, to our earlier point, are the Cavinder girls. What was their deal, and what is the alleged infraction that we're discussing today?
So this is really interesting on a few different levels, because in some respects, the NCAA is really kind of calling these right now kind of NIL adjacent cases. And I think that's important because the NCAA did not come with a proactive bylaw allowing name, image, and likeness. What they did was they said, we are going to suspend our current bylaws that say you can't go out and earn compensation. So there's a nuanced difference there so what they then do is look at it to say, okay, well, is there a violation of our current bylaws in place that someone potentially violated? Now, one more point, and I'm going to get into the facts of the case here in a second, but one more point that's also important to notice is that recently the NCAA said they've been trying to clarify their guidance around name, image, and likeness kind of regulations. And recently, within the last few months, they said that there is going to automatically be a presumption of guilt if we receive a case that there was an infraction around name, image, and likeness. We're going to assume that infraction occurred, and it's going to be up to the school or those involved to prove that it didn't, which from a due process perspective, and me being a lawyer, is most certainly a backwards way to look at it. But I get that, though, from the NCAA's perspective. Obviously, there is a lot then to have to go and try to enforce kind of these name, image, and likeness policies across the NCAA. But this particular instance, this particular case involving the Cavinder twins and the University of Miami women's basketball team occurred prior to that. So this was kind of determined in a bit of a different way, where there was not this presumption of some violation of bylaws or NCAA rules. So what happened? the Cavinder twins, as you mentioned early in your comments, they have been at the forefront of a lot of name, image, and likeness opportunities. In fact, they were at Fresno State at the time. They're twin sisters who play basketball, and they were at Fresno State. And when name, image, and likeness went into effect, they were like in the middle of Times Square in Manhattan in New York doing a promo, I think like midnight of July 1st of 2021 to highlight the fact that they're engaged in this space. So they've been involved. They ultimately decided that they were going to transfer, and one of the schools that they were evaluating was the University of Miami. Now, the University of Miami is interesting because it's also been in the forefront of a lot of stories around name, image, and likeness, primarily due to one of their biggest donors by the name of John Ruiz. And so Ruiz has been in the forefront of NIL news because of deals that he did with the football team, deals that he's done with other individual players and individual athletes at the university. So the question here and the issue that arose was that there was a visit between the Cavinder twins and Ruiz as a donor to the institution. And the question was whether there was a meal provided or not. And if there was a meal, is that an impermissible benefit? Which again, if a meal were provided as part of a name, image, and likeness deal, that's different. Student athlete provides a service. Booster, donor, business provides some benefit, whether that's a meal, whether that's compensation, that's fine. But if it's recruiting and there's no services provided by the student athlete, that still goes back to the old rules that the NCAA has around impermissible benefits. So that's kind of what occurred there. Apparently, the women's basketball coach was involved and had knowledge of this and was involved. And so ultimately, one of the things that's important to note is that, and we'll probably talk about a little bit more about this, but this was a negotiated resolution between the institution and the NCAA Committee on Infractions, which again is important because this was then to say, hey, we're going to agree that these certain activities occurred, and that with these certain activities occurring, here are the penalties that we're going to be comfortable with. Both parties come together, they agree, and it gets written up. Now, that's a quick synopsis of what happens, and I'm sure that you're probably going to want to talk about what happens next. But let me pause and see what questions do you have?
Yeah, no, I mean you've given us a great summary, and it's really interesting to think about the first, one of the big first NIL cases being these two women. I think a lot of people might have perceived the first cases or the first big deals to be of college basketball players or football players, because those are generally perceived to be the biggest revenue generators. But I think the fact that, these twins caught on kind of speaks to the overall sense of what NILs are all about, because it's not just about what's happening on the field. It's very much has to do with social media and your engagement and your influence, right?
Most certainly. And you're spot on. I think one of the
and advertisers are looking for, right? You might be a great player on the field. That doesn't necessarily translate into receivables that sponsors are looking for.
That's right. It's interesting. Name, image, and likeness kind of goes both ways. And in the one instance, you have those athletes who are great performers, elite performers on the field that do have a big social media following because of that and are able to go out and represent brands and companies in the industry and be compensated for that. But on the flip side, too, you also have this younger generation. Now, when I look at social media, I'm the worst. And I admit that. I'm not that good at it because I'll do things like, I'll sit there and think like, what do I want to say? What should I write here? 140 characters or whatever I need. And it's like, oh, I had a great time at such and such event, right? I mean, I'm so vanilla in some respects. But at the same time, this is the student athletes at the college level now have grown up with social media, right? For folks like you and I, it was something that was introduced to us when we already had the ways in which we engage. And so it takes more thought, I think, on our end. A lot of times for student athletes are coming into college with followings that go beyond their performance or athletic ability. So there are student athletes that are doing significant name, image, and likeness deals that don't happen to have, the future professional athlete kind of ability. What they have is somebody that's able to draw a following or a crowd on social media because of other interests and things that they're involved with. So you're right on that point. But the other thing to highlight to your earlier point, when you look at the University of Miami, There's a really fascinating story around Jaden Rashada, who was a high school quarterback who was recruited to Miami, committed to Miami, and there was a belief that it was a $9 million name, image, and likeness opportunity for him. And that blew everyone's mind. And then he decommits from Miami and commits to the University of Florida for a reported $13.8 million of a name, image, and likeness deal that then completely falls apart. And he ultimately has to petition the NCAA to get released from his his commitment to University of Florida, and now is going to, has transferred out to Arizona and is not doing anything in this NIL space that's of significance. To your point, yes, most people thought we were going to see football players and basketball players kind of be that first wave of NIL or NIL adjacent cases being heard by the NCAA. But in fact, we have, the Cavinder twins and women's basketball at the University of Miami.
So why they pick this case? What are the allegations, and what do you think the outcome will be? And again, it's a little interesting to think that the NCAA, hasn't put forth a lot of rules on it, and it very much is the wild, wild west out there when it comes to NILs, given how much money is involved and how new it is, and the fact that you're dealing with, kids, really, right? Teenagers in most cases. And then on the other hand, they are trying to enforce, they are trying to avoid some infractions. So that's a little bit hard to put together. So maybe break that down a little bit for us.
Absolutely. So in terms of the allegations, one of the things that's a challenge for the NCAA is to figure out, how do we deal with boosters? How do we deal with these NIL collectives? How do we deal with third parties that aren't our member institutions? As an association, it's so much easier for us to go after our institutions or to go after student athletes who have violated some of the regulations that we have in place. When you have these third parties, it becomes more of a challenge. But that's also what highlights maybe competitive schools, those who maybe lose out on the recruiting battle for someone to then say, hey, it's interesting. It seems like that person met with this person, and I think that's a violation. And that could be very easily, I don't know that to be fact in this case, but if Ruiz, as one of the probably most well-known donors who has been actively involved in the name, image, and likeness space from day one, having him be involved makes sense that someone might say, hey, we lost out on this particular, recruit or recruits, and we know that they met with this individual, et cetera, and you're not supposed to be using name, image, and likeness or the incentives of name, image, and likeness to induce a student athlete to transfer and to go to another institution. So you can see why the allegations would come to play here, just because of the well-known nature of this particular donor. But when we kind of go through what the negotiated settlement was, or the negotiated resolution was here, what's really interesting is that they contemplated or talked about this idea of a disassociation penalty. And that is significant. And I think in this whole case, that's what the one of the biggest takeaways is, right? Which is the Committee on Infractions said explicitly that they will strongly consider disassociation penalties in future cases that involve NIL adjacent conduct or NIL adjacent scenarios. And what does that mean? So disassociation penalties are those penalties that would say, hey, this donor who caused this penalty can no longer be involved for a period of time with the institution. And if you think about the University of Miami, if they were somebody like a Ruiz who has been actively, heavily involved in the NIL space, but then also just in donating to the institution itself, to the athletic department, if all of a sudden that person now has to disassociate with the university and can't be involved and engaged, that is a major blow to the institution itself, even for whatever period of time that may be. Now, they considered it here. They talked about it here. They didn't feel like that was something that was that they agreed upon in this particular case, but it's something that most certainly is on the table. And I think that alone, in my opinion, is one of the reasons why this particular case is so important. Because I think this is what shares with other donors, other boosters, other NIL collectives who really are operating in almost a wild, wild west capacity, like you mentioned earlier, to say, hey, you all can be penalized as well. Now, does a booster think to themselves like it's a penalty if I legitimately can't give to an institution? So great. Okay, I don't have to give my money this year. I can save on that. But these are boosters and donors who care deeply about their institutions that they're involved with, want to see them be successful overall and successful in the athletic space. And so that is a major potential for penalty that the NCAA could levy.
So look, going forward, how important, I mean, listen, it's obvious that NILs are now a huge part of the recruitment process of the any major student athlete is going to be thinking about considering higher representation for NILs. We saw the famous dust up last season between Nick Saban and Jimbo Fisher about NIL. So this is a big deal, and it will continue to be a big deal as the money rolls in. You mentioned the Big Ten contract. I mean, that's billions with a B, right? These are dollars. So, you're in these living rooms yourself, right? You are talking to a lot of these student athletes. How much are NILs on the subject matter of every coach, every recruiter, every AD, every athlete out there?
So when you start to talk about football and basketball and you talk about elite athletes, it is 100% of the conversation. It's a part of the conversation 100% of the time, right? Yeah. Student athletes are still using other factors to determine where they may want to go to school, things like coaching staff, tradition, opportunity to make it to the next level, facilities, geography, all academics, all those other things. But name, image, and likeness is most certainly a significant part of the conversation for your elite athletes across sports, primarily in basketball and football. There are some sports where it doesn't come up. Or rather, with some athletes, it just doesn't come up, either because they're not that interested in NIL or it's just not something that moves the needle for them, maybe because they just don't see themselves engaging in that way. But when you talk about pretty much any of the elite athletes, especially in football and basketball, it is a part of the conversation 100% of the time.
Luke, last question here on the SERMAPod. You have a long and distinguished career of representing athletes, both professional and now collegiate, right? How does your advice, how does your counsel differ when you're in the living room of a student athlete versus a more seasoned professional?
To be honest with you, a lot of the education is the same. It's just at different levels. So I care deeply about education. In fact, I'm the founder and managing partner of Advanced NIL. So you can check out advancednil.com, where we work with groups of athletes at all levels. So we're representing, we're the exclusive NIL education partner for the public, for Pennsylvania's Public High School Athletic Association. Same thing with Massachusetts, working with probably 40 to 50 colleges, universities across the country, and then work with multiple teams within the NFL and the NBA as well from an education perspective. So when I say these things, I care deeply about the education. At the college level, that education most certainly has to happen with both the student athlete and the parents as well. And that's one of the things that's different. At the professional level, when you're dealing with professionals who are older, who are making professional money in their sport, you're really honing in on making sure that they get and understand this. At the college level, most college student athletes, especially elite athletes, are saying, I just want to make money and I want to perform in my sport. That's what I care about. But what I highly encourage them to also think about are things like the contracts that they may sign and making sure that you are protected and that there is language in the contract that can make sure that you are providing the services you believe you're supposed to be providing, but also receiving on the receiving end of the obligations that company or brand should be providing. Making sure that you understand the idea of taxes and helping families understand how money works when it comes to NIL deals. As when you do NIL deals, you're an independent contractor. And so a lot of times parents don't know the difference between being a W-2 employee or a 1099 independent contractor and what impact that can have from a tax perspective. So helping understand the business side of sports at the college level is most certainly important for both the student athlete and their parents as well.
All right. I promised that was the last question. I got one more just while I have you here, Luke, because we like to get to our guests a little bit more at the end of every podcast. You're around a lot of athletes, a lot of well-known people. Who's the one encounter you had, or one celebrity you encounter, one athlete you encounter that made you really starstruck, made you think, wow, that was an incredible encounter?
Man, this was probably 2006 or 7. And it was the first when I met LeBron James and Dwayne Wade together down in Miami at a restaurant, having dinner with another NBA player who's a client, and these two guys come over to talk with that player, and I'm at the table, and it's just for me it was just kind of like wow, because that was at the same time that I really was kind of just getting started in the sports space. As I've kind of navigated, I don't know what now, 15, 16, 17 years, kind of in this space. The starstruck nature for me isn't there as much because I've had years and years of really working with players to like just protect them like anybody else. And it sounds kind of weird. Don't get me wrong. I love what I do, but I love what I do and I'm passionate about what I do, not because of the celebrity nature of the athletes I work with, but because I know that they have the opportunity to make a positive impact on themselves, their families, and communities. And if I can help protect the possibilities that they have to do that, to me, that's a win. So I can look back at the end of my career and said, I've had a positive impact on young people being able to have a greater impact on the people around them.
Very well stated. The law firm is Porter Wright. The podcast is Protecting Your Possibilities. Luke Fedlam, thank you so much for joining us. Please come back and update us on this and other issues that you're dealing with. We really appreciate your time.
Hey, Rich, thanks so much for having me. I appreciate being on the SERMAPod, man. Thanks so much.